Will democracy survive in the next couple of years?
And essentially, we are the same.
And there are so many needs that Minnesota has.
What people are saying they need right now.
Access to democracy is made possible by donations from the following organizations. Thomson Reuters, a global company with expertise and insight to unravel complex situations in the areas of law, tax, compliance, government, and media. Their worldwide network of journalists and editors keep customers up to speed on relevant global events. Thomson Reuters, the Answer Company. Crutchfield Dermatology, a full-service treatment center in Medi-Spa in Eagan. Their goal is to help you look good and feel great with beautiful skin. With service built around courtesy, dignity, and respect, Mayo-trained Dr. Charles Crutchfield personally treats each patient and is acknowledged as one of the nation's best physicians. Firefly Credit Union, with locations throughout the Twin Cities, has proudly served Minnesotans since 1925. Firefly guides its members forward by delivering customized financial solutions to improve their lives in all aspects of banking. Firefly Credit Union, they light the way with life illuminated. Edina Eye, Physicians and Surgeons, a division of Twin Cities Eye Consultants, has proudly served the Twin Cities for more than 55 years. Now in 7 convenient locations. Using the most advanced technology combined with human touch, Edina Eye offers comprehensive services for dedicated specialists committed to excellence with innovative procedures and expertise for the most advanced eye care.
Welcome to this edition of Access to Democracy. Today, we have the privilege of a guest who is just recently retired as Chief Judge of the Minnesota Court of Appeals and has had a distinguished career in the law. Chief Judge Cleary, welcome to the show.
Thank you, Paul. Thanks for having me.
Now, I have so many questions I want to ask you, but I want to introduce you a little bit to the audience. So where did you grow up and what is your background?
I grew up in a small family in St. Paul and Highland Park and went to Creighton High School, now Creighton Durham.
And well, I'm going to ask you is that when did you decide you wanted to be a lawyer?
Well, my father was an attorney and I respected him a great deal, and he looked like he enjoyed what he was doing, and my skills were verbal oriented anyhow, so I kind of just decided by high school that that's what I wanted to do. Early on, I wanted to be a lawyer.
So where did your dad work as a lawyer?
He was in the Ramsey County Attorney's Office for 35 years and interrupted by 2 years in the South Pacific, World War II.
Okay, but I asked this question for a particular purpose because your dad was on the government side,
yes,
prosecution, but you became a public defender.
I did, yes.
Kind of explain that path in your life.
Sure. Well, 2 things happened. One is, and my father had been a defense attorney for 5 years before he entered the county attorney's office, so that was his beginnings. As for me, I was an intern prosecutor when I was in law school, trying cases as a prosecutor. So we both went in opposite directions, but I was never a full-time public defender. I was in private practice for 20 years, and in 15 of those years, I also did public defense work for Ramsey County, because back then, that's how they did it.
Now, this is the interesting thing. You would not predict this, but your public defender career had a winding path that led you to appear before the United States Supreme Court.
Yes.
How old were you when that happened?
When the Supreme Court took certiorari, I was 38.
Young man, right?
Relatively.
Well, relatively, yeah.
Years. I was 24 when I got law school, so my feet were on the ground, let's put it that way. I wasn't so young that I didn't understand what was going on.
So I want you to tell us a little bit about this case, R.A.V, because it's a very important case and is one of those iconic cases that people look to when they talk about the rights of people. Tell us a little bit about the case.
Well, before I even do that, you may not know this. It's the most cited Minnesota case before the United States Supreme Court in state history. It's even more cited than Neer versus Minnesota. It's number 1.
Really?
Yeah. So let's go back to how it started, because I knew you were going to ask this, so I thought about it. was 30 years ago this summer that a small crossman out of Chair Legs was burned on a family's lawn on the east side of St. Paul. They were the only African-American family in that area. And a number of juveniles and adults were charged with the crime. Now, the prosecutor at the time had all kinds of charges available. The most serious would have been terroristic threats. The cross was there to threaten the family. And there were others too. We almost need to explain hate speech to the public here. There's hate crimes and there's hate speech. Hate crime is when there's a predicate crime. That is, you assaulted someone or burglarized or did something with a biased motive, but you first have to commit a crime. Hate speech is speech alone that is hurtful. It's a big deal right now on Facebook.
I know, your case jumps off the pages of current history.
It just keeps coming back. And the tension there in our country, in our society, because we've always believed in free expression, is whether we can be trusted to engage in free expression even when it's hateful. So that was the case. And anyhow, back then, the prosecutor chose a St. Paul city ordinance that had not been tested, that made it illegal to express an opinion, an intolerant opinion, including displaying a cross or a swastika. But the gist of it was you could be prosecuted and go to jail for a hateful opinion as opposed to any criminal act. And that was what was challenged. Judge Charlie Flynn, who I know you know, Paul,
yeah.
Agreed with me and threw it out. And Minnesota Supreme Court accelerated review, skipped the Court of Appeals, and unanimously found against us and reinstated the law. And Mike Cromit was the attorney with me. And at that time, we had no funding because the state public defender didn't handle juveniles. So we couldn't hand it off to anybody, and we didn't get paid. But we continued to handle the case. And so we filed a petition for a writ of certiorari with the United States Supreme Court. And if you're not a lawyer or a judge, you don't know the odds and what they mean.
Oh, I do know the odds. I mean, somewhere between over 8,000 plus filed a year, and they only grant about 100 or a little more.
Yes. At the time, I think it was 1 to 2%. And I remember when we submitted it, we even had to pay for the cardboard backing because it was an informa pauperis, meaning that there was no money involved. Unlike a private firm that would have stacks of expensive briefs, we had a cardboard covered petition printed at a local printing shop and submitted it and waited. And much to our surprise, but pleasure, the Supreme Court took it. And I found out at 9 o'clock on Monday morning when CBS News called my law office. That's how I found out they took it.
So what was it like arguing before the United States Supreme Court? I mean, this is a rare privilege.
Yeah, it was a rare, exactly, Paul. And I knew that at the time. I mean, I was very much in the moment when I was there. I knew that many lawyers lived their entire lives wanting to get the chance to do this and never had the chance. It's a very, very small group of people that get the chance to do that. Even more so now. There's just very few lawyers that get the chance. So I was aware of it. I had gone with Mike to a moot court, which is a practice argument in front of five former Supreme Court clerks that were professors at Georgetown. And I had argued a month earlier in front of all of them with 150 students behind me. And we'd stop it every 20 or 30 minutes and they would critique me and we'd go on. And in some ways, looking back, that was even more stressful with all those students behind me than going into the US Supreme Court. But on the day of the US Supreme Court, it was December 4th, 1991, just to put it in context. Won't forget the date. And the families were all there because it was portrait day. So all of the justices' families were observing. There were members of Congress there. There were folding chairs in the hallways. And I asked David Strauss about that because David had clerked up there. And he said that it only happened once in his year of clerking up there. So that was very unusual that they allowed an overflow crowd. And it was an inspiring piece of American history. That's how I felt when I was involved in it.
Okay, I got a rather logistical question.
Sure.
I've heard people say that when they go to the Supreme Court, they're surprised how close they stand to the justices. Is that true?
It is true. You're on top of them. And what's even harder initially, I went and observed a number of arguments so that you get a feel for it. But you're not only on top of them, but there's a slight curve in the bench, just a slight one. And the rapid questioning is so rapid that it takes a few seconds to ascertain which justice is asking you that question, because they are right on top of you.
So were you surprised when you won?
When I was going back to the argument, I was surprised at their reception of my argument. They were clearly sympathetic to my argument. I was there with about 17 people, mostly lawyers and friends, and everybody voted as what they thought the vote would be and put it in an envelope and sealed it until the opinion came down. And out of those 17, the one person I remember who picked 9-0 was Pat Diamond, who's now a judge in Ramsey County. He was, so I thought we probably had succeeded. I did not know what was going to happen for sure. And you know, and I know, having done this work, that can be misleading.
Yes.
The argument can be misleading, and you can't be sure where it's going to go.
So there's one side nugget that I want to talk about. Harry Blackman from St. Paul was on the court, and
Yes.
You were told to be prepared for the Blackman question, which was what?
Well, the story, when I was preparing for the argument, I wanted to sit down with a former clerk from the U.S. Supreme Court. So I sat down, Mike and I sat down with Pat Schultz, who's now a federal district court in Minneapolis, because he had clerked for Justice Scalia. And he told us a couple things, but he said, make sure you know where the cross was burned on the east side. And I said, I know where it was 291 Earl Street. I knew the address. And he said, no, you need to know where it is in relation to all the landmarks. Mounds Park, 94. And I said, why would I need to know that? And he said, because Justice Blackman can't help himself. He's going to ask the St. Paul question. He wants to remind everybody that he's a St. Paul native, and he's going to ask that question. And so I did. I went back and looked at the map. So I was all oriented. I was ready for the question, but he didn't ask me. And then Tom Foley, who was on the other side, stood up, and it was the second question out. And it was hard for me not to.
Foley didn't know the answer.
Yeah, no, he was taken by surprise. He said what I would have said had I not known, which is, it's over on Earl Street on the east side. And of course, Blackman just pushed that aside and wanted to know quite a bit more. So there was that tendency, I think, on Justice Blackman to be proud of the St. Paul heritage and to bring that out when a minister.
Well, it shows that judges are human, right? And Blackman.
Yes, it does, and remember their childhood.
But we got to move on to so many other things to talk about. But there were some collateral consequences. Some people gave you a hard time and said that, hey, this was maybe a career thwarting effort to defend somebody who had burned a cross. Is that true?
Was a lot of people did, and very few people thought we were going to succeed before that argument. And a number of, actually a couple close friends asked me why I was risking my career and reputation on it. And I've wondered if the Supreme Court hadn't agreed with me, how the public would have taken it. But on the other hand, to me, it was never a question of holding back. I think people wondered why we were trying so hard. We weren't being paid. It was really, we contributed all that time, and it was simply that we believed in the principle.
So before I move on, I just want to say, you wrote a book about this, and this helped explain things. What's the title of the book?
Beyond the Burning Cross.
So, I would tell people to look for that to see more, because I want to move on to one of the next steps. And
before you do, let me push the book.
Okay.
It's still in paperback. It's still a Kindle, a download, and it's still being downloaded at a decent rate. The Random House put it out, and it's on all websites, Amazon, Barnes & Noble, etc. Okay.
So our careers intertwined a little bit, but they first came into together when you were applying for the directorship of the Board of Professional Responsibility. And the truth be known, this is I was a big advocate for you because I thought that board needed a little more common sense and some outside influence. So if I were to ask you to summarize, this is the board that regulates attorneys. What do you see your legacy as your service as the director of the Board of Professional Responsibility?
Well, I'm going to answer that, Paul. Just so your viewers understand what happened was I had finished the book of R.A.V. and I wanted to change. And you and I talked about this, and you also, you may recall this, we talked about I would serve there 5 years. And I said, that's all I'm going to serve. And you said, that's all we want you to serve, if you recall.
Well, it's all I wanted you to serve.
Well, and in any case, it's exactly, it was almost 5 years to the day that Governor Ventura put me on the bench, if you recall. And it was exactly 5 years. Just to remind people that there's an office of 25 professionals, and then there's a volunteer board. And they regulate the legal profession in Minnesota because we're self-regulated. And the stress on that office in the past is that a lot of lawyers didn't like that office. They didn't respect it, and it was based on certain former directors. Then there were really outstanding directors like Bill Warren.
I'm going to say some people thought they were jackbooted enforcers that had very little sympathy for the law.
As a young lawyer, I thought that myself. So I went in there with some trepidation, and I just really enjoyed working with people in that office and working with lawyers. And I was really concerned, as you know, Paul, that I found that how many lawyers were struggling with psychological problems. And that's when the Lawyers Assistance Plan was established. The court took charge of that. Up till then, it had just been for chemicals, and they moved it into the mental health issues. And probably that's one of the lasting legacies that I'm happy with. The other is that we looked at both the public and the lawyers as best we could. In other words, when a lawyer needed to have discipline, we went full bore after that lawyer. At the same time, when it was not fair to go after that lawyer, we didn't go after that lawyer. Now, you're going to be subjected to criticism no matter what you do in that situation, but I wanted to bring my 20 years of practice into that position and use some, as you put it, Paul, common sense in making the decision as to who to go after it and who not to. And to educate as much as possible the lawyers so they wouldn't get in trouble in the first place.
I'm not going to let you slip by that word educate, because this is one of your major legacies. You got that office oriented on getting out and talking to lawyers and telling them how they could prevent getting in trouble.
Yes, and they're still doing it. And it was a fine professional office, and it was important for us to go out to the lawyers and convince them, we're not here to take your licenses away or to get, unless, of course, you do something that leads to that. But we're here to help you avoid getting in trouble. That protects the public, that protects your profession and your reputation. And so we worked hard at that. And the advisory opinion service, as you know, was a big part of that. The lawyers could call and get an advisory opinion ahead of time before they made a decision that would get them into trouble and might hurt a member of the public.
Now, I'm going to say you got appointed as a district court judge to Ramsey County. And I'm going to ask you if you're a little bit of surprise. And I'm going to go back in time when we were talking about you going to the Board of Professional Responsibility. I said, Ed, that can be a career killer if you want to be a judge. I mean, it's not the normal path that leads you to become a judge. Were you a little surprised when you got appointed?
Actually, no, I wasn't surprised. And let me explain what I mean by that. Actually, Sandy Keith, of course, who was Chief Justice then, told me outright that if I accepted the directorship of the Office of Responsibility, I would not be a judge. And he based Walt Bachman's theory on that, who was a former director. And I wasn't shocked because I thought I had the credentials, quite honestly. And I was happy that no one had poisoned me so bad, which is what happened to Walt, that they convinced the commission or the governor not to go in that direction. But I will tell you, having sat down with Jesse Ventura, that that was an interesting conversation I had with him. And I remember being told by the people and the people involved in the commission, and once you go in that room to sit down with the governor, and it's true, it's between you and the governor. I mean, the governor's either going to feel that you're the right person for that job, or decide that you aren't. And there isn't anything anybody can do. It's between the two of you. And that conversation with Ventura was interesting.
I mean, there's a lot of criticism that can be thrown Ventura's way, but I'm one of those that say that he really took his judicial appointments seriously and really zeroed in on the candidates to make sure they fit what he wanted to have done. Did you feel that?
I do feel that. Of course, I'm biased because he appointed me, but I will say that of any governor in my lifetime that I'm aware of, he balanced people from different backgrounds, political parties, political interests, independents, and the result was he wasn't paying. I won't say paying off, but he wasn't appointing old friends or assistants. He appointed people that the commission, and the commission did a fine job, had given him, and I think he had a good sense of people. I know he gets criticized. I think if he'd had a thicker skin and could handle the media and had been more self-deprecating, that the sky would have been the limit for Jesse. But he just couldn't take that part. But I think he did a very, very excellent job appointing people, judicial branch, and we're still seeing people.
I'm going to touch a little bit on your legacy on the district bench. I do want to get to the Court of Appeals.
Sure.
But you had some interesting things happen to you on the district bench. You're in the trenches, jury trial. But you were also on the Coleman Franken canvassing board, were you not?
Yes, I was assistant chief at the time. Kathy Guerin was chief. And so we joined Eric Magnuson, who was then Chief Justice, and Barry Anderson, who was another justice on your court. And the four of us, along with Mark Ritchie, who was Secretary of State, handled that. That was the end of 2008 and early 2009. That was an interesting experience.
But I mean, I tell people is that I can't say who got the most votes, but I can say who got the plurality of validly cast votes in that election. I mean, and a lot of that is due to the transparency of your canvassing board proceedings.
Well, I hope so.
Like you had cameras there, you were holding up ballots.
Yeah, I hope that people still come up to me to talk to me about that. It's 11 years later, and I hope that the public really does understand that even though all the five people that were at that level that were looking at it came from different backgrounds and probably had different political viewpoints, had never entered into this. We just did everything openly. I mean, it was there, as you said. The cameras were watching. There was no backdoor smoke-filled room there. Everybody was doing it out front. So what happened is what happened. And it was an interesting experience. I enjoyed working with the others. We got to know each other a lot in a very short time.
Yeah.
And it was interesting. As you know, on your court, it was also must have been an interesting experience. I remember a dissent from one of your justices that was pretty angry.
So we were the final, there were five of us who were the final deciders.
Yes.
I am so grateful to the work of the canvassing board and the three-judge panel who reviewed your work.
Yeah, I agree.
I thought that we as the Supreme Court might be having to minutely examine ballots, whatever, but you were so transparent in how you did what you did that you instilled a lot of public confidence in your style and procedure.
And that was our hope. I think that was the hope of all five people that were on there. I mean, the chips fall where they fall, but you just do it out in the open so everybody can see what's happening.
Who appointed you to the Court of Appeals?
Well, Governor Dayton made me his first appellate appointment in November of 2011. So I was the first one for him, first of many.
Okay. And then you became chief of the court. And who appointed you there?
Again, it was Governor Dayton, and that was in August of 2013. And that, of course, was after I was a finalist for your position in the Supreme Court when Dave Lilhog was appointed. Two of us were in a fairly tight race, I think, and the governor wanted me to be chief judge of the Court of Appeals, and that's where I ended up.
I mean, I'm not going to go there. I mean, both of us have experienced the disappointment of being passed over, you for the Supreme Court, me for Chief Justice. And it's hurtful, but you move on. But
it's hurtful at the time. I will say that as time goes by, at least in my case, I was chief judge for 6.5 years, and I grew to enjoy the position, and I grew to, and you were there for a while too.
Oh, yes.
And I really did enjoy it, and I think that maybe the governor knew what he was doing. I was very disappointed at the time, but life is a way of working out, and you need to be flexible and adjust. And I still feel very close to my colleagues.
Now, here's the thing I want to get a little bit into your tenure as such, but here's the thing I want to make sure I leave people with that I really impressed with you. I mean, we talked about your common sense. But we talk about your sense of doing justice. But there's something more to you as a judge. I mean, it reminds me of a phrase I used from the movie The Winslow Boys, that doing justice is the easy part. Doing the right thing, that's the hard part. There's some hard part to not only doing justice, but doing the right thing. Could you elaborate a bit on that?
Well, you know that as well as I do. And having been at both levels, the trial judge and appellate judge, you do see that up close. And you and I, in talking about this, mentioned, part of doing defense work for all those years is that you have a very strong memory of what it's like to be indigent and desperate. And once that really, you can hear it, you can read about it, you either live it or you pick it up by the way that your life is led, either as a legal aid attorney, and you did VISTA, so you know that, or as a public defender, and you pick up really exactly how desperate indigent people are day to day. And in the Court of Appeals, there was a case where a man had been convicted of a criminal sexual conduct charge, although it was an age issue involving two people, and he was ordered, even though he was homeless, he was ordered to pay for his sexual treatment to address his issue. And the judge, he didn't come up with the money because he's homeless. And the judge violated his probation and sent him to prison. And I took issue with that in a dissent, and I still take issue with it. I think sometimes we're so insulated. I think right now is a good example of that a lot of us are inconvenienced. I mean, I retired into a situation where I hope to travel and do all kinds of things. That's inconvenience. There are millions of Americans now that don't know literally what's going to happen next week, next month, in terms of jobs, housing, and to send someone to prison for not being able to pay for treatment, it undervalues the public safety. I mean, you want that good person to be treated. And it also sets them up for failure because you're going to be worried about where you're going to spend the night and where your next meal is. So every so often, I think judges get a blind spot. They kind of forget what it is they're doing, and that they need to remember that you still have to put yourself in the other person's shoes. That doesn't mean you don't send people to prison when they deserve it, but it does mean you need to understand where they're coming from.
So you would agree with me and others that a judge needs to be able to put him or herself in the other person's shoes. I believe it's called empathy. You need to understand it.
If you don't have empathy as a judge, well, you know and I know what the virtues of a judge are: decisiveness, civility with others. But yes, empathy is right up there, maybe at the top. You need to have it.
So I'm afraid that I'm going to have to ask the indulgence of our producer to do another show with you to get into the specifics of how the Court of Appeals work. But I wanted to illustrate to the public is that the qualities that make a good judge. And I think that you bring so many of those qualities. So, but I was on a personal note, you've now retired as chief judge. What's next for you?
I'm not entirely sure. I decided that I'd been chief judge, I'm second longest serving judge. And I thought, Governor Walz is coming in. I'm really impressed with my time with the governor. And I thought, well, I think the governor should have a new chief. And then he asked me to stick around. And so I did. And now I retired at 67. I can do senior work as a judge in the Court of Appeals, and I may do that. I may do other things. I just got, my wife just retired in May. So we'll travel when we can. We just got a new rescue puppy. I'm playing tennis and golf to try to stay active. So like many people.
So I've got a question for you.
Sure.
Is that I somewhat limit the venues in which I appear after being on this. You kind of like me, have been chief judge of the Court of Appeals, like myself, a justice. You can be an 800-pound gorilla in the room when you get involved in the case. Do you notice that?
Well, I do, and that's part of the reason I haven't been near my court for 2 months. I'm trying to get out of the way for the new chief judge, Susan Siegel, and yes, you have to pick and choose what you're going to do from here.
Well, Chief Judge Edward Cleary, thank you for appearing on the show. This has been fun. I hope people get a sense of you and what a good judge is about, and I'm going to see if I can get you back. So thank you so much.
Thank you, Paul.